because I'm concerned about time constraints, a couple of things flowing from that. Are you aware of any decisions, and perhaps this is a double-barreled question, are you aware of any decisions of the ATO where an organisation has been knocked out in terms of any religious status, so that it won't get a tax-exempt status? And secondary to that, do you have any views as to whether you think, from your research, that the High Court's decision in 1983 in relation to the Church of the New Faith could be subject to further review, or do you think there's scope there for the High Court to look at these matters?
Oh, absolutely. Well, it's a good question, because I did mention in my thesis there was a decision, I believe, now this is second hand, but I read a submission that was made to the Shepherd Inquiry, and it talked about a group known as the Raelians. Now, they're the followers of Elohim.
How do you spell that?
Elohim, and Raelism is a group that follows Elohim, who are an advanced race of extraterrestrials who created life on Earth. Now, the State Department of the United States says this is a religion, I believe, but the thing is that this religion was established by Claude Rael after an encounter with a little person in a green suit from a UFO in 1973. Now, apparently, the story is that...
That's a fact, or are you alleging?
What was he saying?
It's a fact. Eh? I'm sorry, no, well, I'm just stating that he believed it to be a fact.
Yeah.
But the thing is that, and then I'm subsequently setting up embassies for the visits of the Elohim. But interestingly enough, apparently, they were denied religious institution status because they didn't qualify as a religion by definition.
Here in Australia?
In Australia, I believe so. That was what I've mentioned in my thesis here at page 430, actually. But it's interesting why. It's because there's nothing supernatural about meeting someone in a space, in a flying saucer. They're real. So that would have been the reason for them being denied religious status. Now all they have to do is change their scripture and say, well, really what emerged was a spirit, and then they would get religious definitional status. What I'm basically saying here is the sort of the definition of religion, although it is an expanding and very wide definition in Australia through which you can drive every cart. I mean, you can have a group of Viking revivalists who would probably quite easily qualify as a religious institution, and frankly you might wish them to qualify as a religious institution for the purposes of marriage, or say they would wish to conduct a funeral service, you know, with Valhalla and so forth. So you could in fact have a very broad definition of religion, so long as you can apply public, and that would also protect the aspect of section 116 of the Australian Constitution talking about religious exercise and religious freedom. But at the same time, I don't think there's any problem whatsoever raised by section 116 in applying public policy parameters to the privileges afforded to groups that get the status of religion by definition, because the definition is an ever-expanding definition. It could well be, and in fact if you look at various countries, in India for instance it's more of a spiritual group. Sometimes it's been contemplated now that an equivalent belief to religion would also qualify as a religious organisation. So the word religion is an expanding dynamic and almost impossible to define. Now the Australian High Court gave an opinion on that, but it was in its appellate jurisdiction, and I don't think people realise this. Not only that, the Australian High Court was extremely hamstrung by the fact that the pleadings before it limited its consideration of this matter.
This is the 1983
That's the 1983 Church of the New Faith decision, or the Scientology decision. So that decision, I think, really needs to be looked at very closely. You can either have an extremely broad definition of religion to cater for the free exercise component, in which case you could have a witches' coven, which is recognised as a religious institution, and celebrate marriage and so forth or whatever. and perhaps no harm done. But at the same time, you might not wish to have a group becoming a charity with all the privileges that entails, and also the fact that you're giving them state sanction to conduct certain activities in the public you might not wish certain groups to conduct. So it might seem a bit complicated, but it isn't all that complicated. And I don't think the High Court would balk at proper public policy parameters to the privileges that are given to these groups.
So you're saying that, in essence, are you saying that freedom of religion does not necessarily mean, under Section 116 of the Constitution, does not necessarily mean that you get tax-free status?
Exactly. But of course, it might mean something in the sense that it does mean something, and it could mean that you have the right to free exercise of your religion, perhaps in company with others, but it doesn't give you that right then to go and do other types of activities in the community that the state doesn't want to subsidise you for, in my view. I mean, I've been working on this for a number of years, so it seems a little bit more understandable to me, but I can understand how the very definition of religion is mind-boggling if you're sort of encountering this this aspect of it really for the first time, because it is so vague and could jump either way.
And finally, Dr. Mutch, so I think my other colleagues have questions to ask of you. Is it your understanding from the work that you've done on this that this has not, the public benefit test as applied in the United Kingdom has not been unreasonable or onerous with respect to the operations of those organisations?
Well, as I said before, look, that's really something that I rely very much on the Australian Tax Office's statement, where they said that it's not, it's not the last thing, not the worst thing in the world to happen. But I'm also saying that there's probably other ways to attack that particular problem without being too onerous to all those genuine groups that we all know do good work in the community. I think there's a number of mechanisms that you could consider that would trigger a reversal of an onus. Yes, sorry.
Sorry. Finally, the ATO in their submission, I think, was saying that they weren't really looking, that the UK doesn't look at detriment. You're saying that's not quite the case, is it? Because they actually do have to balance benefit and detriment. Is that your understanding of the 1999?
Well, in my understanding of the earlier case is that they did look at that insofar as that was required for them to determine whether or not the reversal of the onus should occur. It gets a little bit complicated, doesn't it? So yes, of course, they did consider that. They did consider that. And then they looked to see whether the body itself was then performing a public benefit. And they said, well, if they'd decided the case on that basis, they wouldn't have been either. But this is where I think the ATOs, and this is where these organisations like the ATO and the Charity Commission are crying out for legislative guidance with a bit of strength so they can make these decisions. They like to say they're only applying precedent decisions, but in my view that really creates a lot of holes because a precedent hasn't been created under a number of circumstances, and that's why I pretty much admire what's been written in this bill, because you're setting out quite clearly a number of public policy parameters that we need to look at, and I think are very relevant to this. Now, of course, in my thesis, I proposed a mechanism where an adjudicative body would be set up, and there's been other proposals for that type of thing. But I don't see any reason to sit on our hands and not start to require this to happen now. I think that it's all very well to say we've got to do all this at once and then delay it to the never-never. When there's very real concerns out there. Senator Cameron talked about the amount of money that organisations in default receive because of this wonderful gift of tax-exempt status. And the very few organisations that probably don't deserve it, I think we should be looking at. I'm not sure how few or how many actually, because we just don't have the information.